Welcome to this week's edition of World Crisis Radio. This is Webster Tarpley speaking from Washington, D.C. And as I address you, it's the afternoon of Friday, February 10th. And we are in the aftermath of the landmark action by the Ninth United States Circuit Court of Appeals, primarily in San Francisco, although as the result of a multi-location conference call, which has upheld the temporary restraining order, TRO, issued by Federal District Judge Robart in Seattle some days back, which prevents the administration from enforcing its measures, right, including the ban on entry into the United States by citizens or, I believe, people born in those 7 countries, that is to say, Iraq, Iran, Libya, Syria, Sudan, Somalia, and Yemen. That would be the 7. It also stops all entry by refugees of any kind. So Judge Robart had issued a TRO, a temporary restraining order, and the opponents of the measures of the administration, led by the state of Washington, the Attorney General and the Solicitor General of the state of Washington, joined then by Minnesota, had, sought what ultimately would amount to a permanent injunction against this executive order. Now, we are very much in the thick of things, because remember, none of this action, including especially the executive order, and that executive order is now getting on to be about 2 weeks old. That executive order has never been examined in terms of its inherent merit or lack thereof. In other words, whether the content of this is constitutional or not is not even the issue so far. The issue is, since there is objection coming from these states, and there are more states raising objections as we go along, since there is this objection, there's going to be a legal proceeding. There is going to be judicial review, and this is the big phrase of the day as far as I'm concerned. I want everybody to stay tuned to this program, because we're going to do a summary of judicial review, both in terms of the opinion, this 29-page opinion coming from the 3-judge panel of the Ninth U.S. Circuit Court of Appeals, and but also then going back and looking once again with more detail about the origin of this and what is at stake, because the stakes involving judicial review are simply huge. It is there a government of laws? Can the courts object, stop, strike down actions by an out-of-control Congress or by a misinformed executive? Can they do that, or is there no such judicial review? That became an issue. That was not originally an issue in this, but because of the arguments by a certain attorney of the Department of Justice in the conference call the other night, which was available, it was live streamed, and you can hear the whole thing. It's about an hour. I'll try to give you the key part, but you should listen to it, because what you got here is the question of reviewability. Means, is there such a thing as judicial review? In other words, is the executive branch above the courts? Is the executive branch essentially superior to the system of laws? And that's of course a very big issue. So we want to do this in quite a bit of detail. But just as in terms of our current situation, there is no decision on the merits. The merits have not yet been considered, right? Whether The executive branch has a right to do these things. However, what we do have is a judicial track record now, and it looks to me like it's 9-1 in favor of the people who want the temporary restraining order. 9-1. During the first weekend of the ban on immigration from those 7 countries, there were a number of narrow cases that were decided by once by a federal magistrate, a lower level judge, and then 4, I believe, by U.S. district judges. And those involved, I think, either individuals or small groups of people. And five that went essentially 5-0 in favor of allowing green card holders, permanent resident aliens, and others to come into the country. We then had the hearing in the court of Judge Robart in Seattle, who issued the temporary restraining order. And we've just had a 3-judge panel, an Obama appointee, a George W. Bush appointee, and a Jimmy Carter appointee. They have essentially opined unanimously that this temporary restraining order will stand. It will remain in effect. There is one opinion which goes in the other direction, and that is a federal district judge, I believe, in Massachusetts, who essentially looked at it from the other point of view. But this is essentially a 9-1 score. Now, what will happen? We've just had the press conference of the president in the East Room with the Japanese Prime Minister Abe, and there was a reference made there to what the administration will do next week. Something important in terms of national security is supposedly forthcoming. We'll wait and see what that might be. We'll be looking at it carefully, needless to say. But there's also then the question of this case, and the president announced that he would vigorously pursue this case. So that would argue a legal process that would go on. Now, what that might be. There is this question of an en banc review. That is to say, we've just had a 3-judge panel of the 9th U.S. Circuit Court of Appeals. En banc would mean all the judges in some of these U.S. circuits, of course, in the 9th Circuit Court of Appeals, right, stretching from Washington State to Oregon to California, above all, to Hawaii and I think Alaska too. They have about 40 judges in their appellate ranks. So in the 9th Circuit, apparently en banc means 11 of them would form a panel and then rehear some arguments in some of the case. So that could happen. That could be the next step. There could be then an appeal directly to the Supreme Court, which I believe would go through the Supreme Court justice who supervises and has responsibility for the 9th Circuit. That is Anthony Kennedy, Justice of the Supreme Court, thought to be the decisive factor. In other words, he's the swing vote in the or has been in the Supreme Court, and might be again. So it might then go to the Supreme Court, but the Supreme Court might refuse to take it. The Supreme Court doesn't have to take it at this point, or indeed any other point, if they all vote that they don't want to, or majority. Back in a minute on World Crisis Radio. Welcome back. Washington, D.C., and I want to remind everybody to keep up with this analysis day by day, Monday, Tuesday, Wednesday, Thursday. Please do take a look at americansystem.tv, americansystem.tv, and I urge you to subscribe to become a a member, essentially, a supporter of this effort. It's a nominal fee, and with that you get to hear the analysis of these developments day by day, not just week by week, but day by day, sometimes hour by hour, depending on the time factors. So once again, the Ninth United States Circuit Court of Appeals, the biggest, in some ways the most influential, the bellwether of this entire appellate court system, they have said that the temporary restraining order against the travel ban, immigration ban on entry into the U.S., that is going to stand for the moment. So we don't know where the next step may go. The other possibility, in addition to the 11-judge en banc panel of the Ninth Circuit, that's one, there's the appeal to the Supreme Court. Supreme Court maybe takes it, maybe not. They decide. Remember, in the U.S. system, you have a statutory right to appeal to the U.S. Circuit Court, but you don't have a statutory right as an individual, especially to appeal to the Supreme Court. Now, if you're a case of this importance, maybe that's different, but that's not guaranteed. That's not automatic. So what we're hearing, especially from the various commentators, is that the Supreme Court does not like to take these, what you'd have to call an interlocutory or interim appeal. That is to say, the appeal to the Supreme Court to try to shut this down by saying, for example, that Washington State and Minnesota don't have standing, do not have standing. That could be a finding that they could advance. And that would essentially shut down this particular case. Although others are coming forward, right? The New York State Attorney General Eric Schneiderman is putting in his appeal or his contentions, his suit, to try to block the executive order. We've also got the state of Virginia with Governor McAuliffe and the Attorney General there saying that Virginia is being harmed. So those are coming forward. But it's theoretically possible that there could be this interim appeal to the Supreme Court, which might prove decisive. But then again, the Supreme Court is 4-4, at least unless and until a new justice is confirmed by the Senate. It's a tie, or at least it's assumed to be a tie. There were some commentators who were speculating maybe it wouldn't be a tie. I don't know. I think that I didn't hear any evidence that would be the case. I just heard speculation from people whose speculations have sometimes not exactly panned out. So that's also a possibility. Now the other possible outcome is that it is sent back through some mechanism to Judge Robart, and Judge Robart would then have a trial. He would then have he would be the trial court, and he would preside over a civil litigation. And in the course of that, as the Attorney General from the state of Washington and the Solicitor General of Washington were pointing out, they would use all the tools of discovery, all the tools of deposition, all the tools of finding out the case in advance, right? If it's contended that this was in fact a Muslim ban, which has been camouflaged cleverly, as former Mayor Giuliani seemed to be suggesting the other day, then his views might then be required. Or others in the White House, and that could include anybody in the White House. There was an attempt by commentators to say, well, does that really mean everybody? Would that be the chief executive as well? And the answer from the Washington State Attorney General was it is that he intends simply to use all the legal tools at his disposition. So there it is. Let's just look at some of these issues now. I would urge you at this point in the broadcast to go and get the opinion. That is to say, this is one of the vital documents of our time. is the opinion of the Ninth U.S. Circuit Court of Appeals in the case of State of Washington v. Trump. You can get this at the New York Times website. If you've run out of free articles for the month on the New York Times website, you can go to CNN. Maybe you better go directly to CNN because they have it up. And the headline is full text, Ninth Circuit rules against reinstating travel ban. Travel ban will remain blocked. A federal appeals court ruled Thursday. Read the court's ruling below, and there you have it. You should try to read along with this because it is absolutely fundamental to understand where we are and the political predicament that we're operating in. Now, just a brief, quick preliminary overview. We mentioned the question of standing. Who has standing? In order to bring one of these civil cases to sue the government, essentially, you got to prove that you've been damaged, that it's hurt you. And the courts have made this much narrower, much harder, much more direct than it needs to be. Like, you could go in there and say, well, my rights have been taken away. No, that's probably not good enough. You got to be more specific. So the standing argument, and this was made especially by the state of Washington, and again, their Solicitor General was the guy who did the arguments. The argument there is that the state of Washington has state universities. They depend on professors, researchers, scientists, visiting lecturers, academic exchanges, and so forth. And this requires people to be able to come and go into the United States. Right? It would have been theoretically possible to have Boeing or Microsoft or Google could have been in there saying, we have facilities in the state of Washington and we can't operate in our normal way because we also depend on getting employees from abroad, sending salesmen abroad, all the rest of this. You've got to prove that somehow you got skin in the game. They did, and we'll get to this now in just a second here on World Crisis Radio. Welcome back to World Crisis Radio, continuing with our review of the Ninth Circuit, and then the real heart of the matter, which is, what is judicial review? We've been talking about this day by day on the other program, on the American system, and we've got to do justice to it here, because this is the lasting, permanent, fundamental aspect of what's been going on, right? If you go back and just look at the headlines for the American system that came out on Wednesday night, we were saying that the issue was reviewability, meaning judicial review, meaning something that goes back to Marbury versus Madison, 1803. You can take it back further, and we will today. But in terms of the controlling precedent, so to speak, we would say it's the great Chief Justice John Marshall of Virginia and his opinion in Marbury versus Madison, 1803, that the Supreme Court can review, meaning pass judgment on, either affirm or void, strike down, actions of the legislature, to be sure, but also of the executive, right? It's not personal. This is a principle that has been validated through the ages, right? This is one for all seasons. This is not short-term pragmatism. All right. So standing. Now, why is the standing important? Look, you got to prove that you've been harmed. So the government of the state of Washington can come and say, we operate public universities. Our public universities are being interfered with, harmed by the results of this executive order. And this carried the day. According to the Ninth Circuit, that's it. It's you don't need any further arguments. You've proved standing. And this is not unusual. Let's go back to the case of the Dreamers, right? This was the executive order by Obama, right? Same idea. Executive order concerning immigration. And the point here was the so-called DACA, right? The deferred action on the children of arrivals, I guess it is. In other words, the children who were not born in the United States, they were born abroad, but they were brought as minor children into the U.S., and they would now like to normalize, regularize their lives and not be seized and deported. DACA, the dreamers. So what happened was the opponents of this found a federal district judge in Texas who was willing to accept the argument that the Texas Department of Motor Vehicles was being forced to issue driver's licenses for these theoretically illegal, undocumented aliens, and therefore the state of Texas had standing. The Attorney General of Texas had standing. Well, I hope that what is sauce for the goose is still sauce for the gander. If you could use that argument against Obama and the DACA, then certainly the state of Washington, and if need be, the state of Minnesota and New York and Virginia, all of them, any state, can certainly prove standing because of what this executive order might do to them. So the states have standing. Then there's, of course, due process. And remember, this is quite fundamental. This is the Fifth Amendment, right? During the election campaign, we developed a kind of a litany, I guess you'd say, of the various amendments that were in danger. And here in the Fifth Amendment, we read, no person, and then we skip a whole series of provisions, but no person shall be deprived of life, liberty, or property without due process of law. Now, the helpful opinion by the Ninth Circuit actually says what that means. What does due process of law mean? It means that you've got to receive notice that this is going to be done to you, and you have got to be able to respond, to give reasons, and to have those reasons considered. And it's clear what they mean is by a court of law, not by an official of the executive branch, not ICE, not the customs and immigration enforcement or whatever it is, but by a member of the independent judiciary, right? In some way. So, no person, and notice it says no person. The Constitution generally does not talk about citizens. It talks about persons. And what they mean by that is anybody under U.S. jurisdiction acquires certain rights. This is fundamental. And you can't say, oh no, those damn foreigners, they don't get any rights. Yeah, they do. Otherwise, what Constitution do you have? Not the one that I'm reading. Not the one from, 1788 or 1787. I'm sorry. Maybe validated a little bit later. But it talks about persons, or the accused, right? It doesn't say the citizen who is standing trial. So this is also extremely important because the administration contention through the Department of Justice lawyer, who's a guy called Flint J, Flentje, he was saying, well, these are, only citizens have these rights, right? The government argument seems to imply that others don't, but they do. They do. So, due process. Everybody gets it. Isn't it wonderful? Due process. And again, this is no small matter. Lots of people have died for this, right? When you look at all the dead in all those wars, including the Civil War, what was it? It was all the struggle to preserve, protect, and defend these rights, right? And here they are in written form. Now, then we get the renewability. the reviewability. Now, this arose in the following way. This was actually added into the case, as far as I could see. It was implicitly there, but it became explicitly there during the proceedings, during the arguments. One of the three judges, and that is Michelle Friedland, I believe she was the Obama appointee. Michelle Friedland asked the government lawyer Flintje, are you arguing that the decisions of the executive in matters of national security, or which you claim to be national security, if that's really what it is, are you claiming that those cannot be reviewed by the courts? In other words, that they are inherently, ipso facto, unreviewable? And then we got what I think is going to go down in history as the longest pause in the recent history of maybe of American jurisprudence, where the government lawyer did not know what to say. And eventually, after 30 seconds of crickets, he said yes. He actually said the yes. Yes. But the answer was yes, in quotes, from Flintje. So he says, yes, it's unreviewable. In other words, you judges have no business even asking me these questions, right? An unbelievable assertion. And certainly, as the opinion says, this would break then with the tradition that we have. I would also point out, in terms of this court proceeding and the findings, it would have been possible to document the government claims, but this was not done. And we'll be right back with that in a minute here. Welcome back to World Crisis Radio. We are continuing our review of these judicial proceedings, and the issue we've now come to is the proof. The government contention, now repeated in many forms, right, in many formats, in many places and auspices, is that there's this imminent terrorist threat to the United States. I have to pause to point this out, right? Some people who were anti-establishment people thought that by voting Republican in the presidential election, they would be voting against what they thought would be undue reliance on fear and related things, the fear of terrorism. They thought that there had been too much of that the Democratic candidate was too much in the thrall of various neocons who were known to traffic in scare tactics and things like that. And they thought that with the Republican ticket, that with the irreverence and the refusal to simply accept certain received ideas, they thought that would be possibly a way to avoid what they didn't want. And it turns out, no. The basis of all this is that post 9/11, there is this existential threat of terrorism, and therefore these measures have to be allowed. So the question then was, well, you say that there's this threat. What's the threat? Can you give us a predicate? Can you give us a credible, concrete piece of evidence that there is such a threat? And at that point, the government attorney, once again, from the Department of Justice, was unable to supply any specific documentation. And the opinion here of the Ninth Circuit points out, don't think that federal courts cannot be shown top secret material. No, they can be, and they often are. Federal courts, district court, appellate court, Supreme Court, they're always getting shown various kinds of secret, top secret, cosmic sorts of information. So they don't leak. generally speaking, they do not leak. So that is not really an objection. So if you had wanted to make this case that there's too much danger to allow this to go on, right? That the TRO has to go because of the danger in the world, then fine. Then bring some stuff that would back that up. Not done. But then let's talk about reviewability, because again, here I can't say it much better than now. If you've got your opinions there, right? You've gone to CNN, full text, Ninth Circuit rules against reinstating the travel ban. This was posted at 7:15 p.m. Thursday evening, last night, February 9th, 2017. And what do we find here? The interesting parts, I would say, are from about page 14 through about page 29. And I'm just going to give you some of the key parts, right? Maybe also some of the quotes from the cases, because they have a whole lot of case law, needless to say. Quoting now from the court. Now, this is the court. It's not just the three judges. That is to say, Friedlander, Canby, and the third, right? Which they're listed at the beginning of the opinion. You got them there. And again, 2 Democrats and 1 Republican, I guess we can say, based on who nominated them. And the district judge was a Republican. So this is not a partisan opinion in that obvious, rather crude sense. But they put at the beginning that the opinion is delivered per curiam, C-U-R-I-A-M. Curia, meaning lots of things, but in this case, the court. Per curiam, it's from the whole court. It's the three of them are agreeing with this, right? Because it's a unanimous opinion. But they also want to add that this is the voice of the Ninth Circuit, right? At least as far as we've gotten so far. So what do they say? Quote, "There is no precedent to support this claimed unreviewability, which runs contrary to the fundamental structure of our constitutional democracy." And they go back to Boumediene versus Bush, 2008, where the legal opinion, the finding of the court, rejects the idea that even by congressional statute, Congress and the executive could eliminate federal court habeas corpus jurisdiction over enemy combatants. And the reason that they can't do that is because the political branches, meaning from the point of view of these guys, it means the president and the Congress, the political branches lack the power to switch the Constitution on or off at will. Within our system, it is the role of the judiciary to interpret the law, a duty which will sometimes require the resolution of litigation challenging the constitutional authority of one of the 3 branches. And the Ninth Circuit, the 3 judges, then continue, we 3, and we, the Ninth Circuit, are called upon to perform that duty in this case. But what about the claim that the president, runs foreign policy, runs defense, that his judgments are, again, unreviewable? Quoting, "Although our jurisprudence has long counseled deference to the political branches on matters of immigration and national security, neither the Supreme Court nor our court, the Ninth Circuit, has ever held that courts lack the authority to review executive actions in those arenas for compliance with the Constitution. To the contrary," as we're still reading here on page 14 of the opinion. Yes, page 14 of the opinion. "To the contrary, the Supreme Court has repeatedly and explicitly rejected the notion that the political branches have unreviewable authority over immigration or are not subject to the Constitution when policy making in that context." And we're quoting case law now. We won't go through all the details of this, the names and so forth, but immigration is subject to important constitutional limitations. This is a rejection of the argument that Congress has unreviewable authority over the regulation of aliens. And it shows that the courts can review whether or not Congress, for example, has permissible means of implementing that power. So the idea here is always the president is entitled to substantial, very large, vast deference on these matters, but it's not absolute deference. It's not carte blanche. It's not a rubber stamp. It's not silence. It's not, we can't take that case, but rather that they do have this right. And of course, when you say review, the right to review, if it's going to mean anything, necessarily means that you get the right to turn something down. In other words, you can review it and you can then find, yes, this can stand, or no, we're gonna strike it down, in effect. So, the government, essentially the court says the government is trying to distort some quotes from one case, the so-called Mandel case. Mandel challenge, but they're saying, no, you sort of taking that content and then giving the wrong conclusion. So we'll be back in just a minute with more from the Ninth Circuit, and then some more from Chief Justice John Marshall. Welcome to the second hour of World Crisis Radio. It's Friday, the 10th of February, as we're recording here in Washington, D.C. It's a cold day here, and we had a brush with a snowstorm, which has, of course, hit New York, Hartford, Boston, and points north, right? North of Grand Central has been hit by a significant snowstorm. But here we are, and reviewing the opinion of the Ninth U.S. Circuit Court of Appeals. This is one for the textbooks, and again, I urge you to go to CNN and look it up and follow along as we go through it. Right now we've reached, let's see, we're on page 15, and we're not going to do too much more of this, but I just want to give you the general idea and a bubble on this question of judicial review. We will then pass to a kind of historical treatment of that, of course, because how did we get this? Just remember that one of the precedent cases which these three judges cite is that, and I think this refers to the Supreme Court, if not the Ninth Circuit, this court has never held, they say, citing an earlier case, nor must we now be understood as holding that administrative officers, when executing the provisions of a statute involving the liberty of persons, may disregard the fundamental principles that inhere in due process of law as understood at the time of the adoption of the Constitution. That sounds like an originalist view, but the originalist view in this case converges on the fact that there is judicial review. The present case, right, these Ninth Circuit judges, by contrast, is not about the application of a specifically enumerated congressional policy to the particular facts presented in an individual visa application. This is, rather, the states, Washington and Minnesota, are challenging the president's promulgation of sweeping immigration policies. So they distinguish between the case-by-case stuff and so forth. While counseling, we read on, while counseling deference to the national security determination of the political branches, the Supreme Court has held that the government's authority and expertise in such matters do not automatically trump the court's own objection to secure the protection that the Constitution grants to individuals. National defense, this is one of the most eloquent, national defense cannot be deemed an end in itself, justifying any exercise of legislative power designed to promote such a goal. It would indeed be ironic if, in the name of national defense, we would sanction the subversion of those liberties which make the defense of the nation worthwhile. Just because a statute deals with foreign relations does not mean that it can grant the executive totally unrestricted freedom of choice. So they do, the federal courts do review it. The question of denying habeas corpus to so-called enemy combatants in the post 9/11 era under George W. Bush is cited, and the shameful episode, I believe, attributable to John McCloy and Colonel Stimson of interning the Japanese Americans during World War II. They cite those too, but what they're doing there is not endorsing those things. They simply said, in both of those cases, we did review it, right? And they came to, greater or lesser, better or worse results. So they then go through what it takes to get a stay. And again, the finding is that the states have shown it, right? And this is important too, because even though we've been saying that these opinions are not intrinsically focused on the merits, there is this question: in order to get a TRO, the judge giving you the TRO has got to feel that it's likely that you will prevail ultimately based on the evidence that has been shown. And now we're up to approximately page 19 in the opinion. The government has not shown that it is likely to succeed on appeal on its arguments about at least the state's due process clause claim. And we also note the serious nature of the allegations the states have raised with respect to their religious discrimination claims. We express no view as to any of the state's other claims, but they're essentially saying we don't see how the government is going to have a cakewalk here, so there is a reason to keep this TRO in place. The government has not shown that the executive order provides what due process requires, such as notice and a hearing prior to restricting an individual's ability to travel. Indeed, the government has not contended. This is now page 20. Hang on, we've skipped ahead an extra page here. The government has not even contended that the executive order provides due process. There's no claim of that. Rather, in addition to the arguments addressed in other parts of this opinion, the government argues that most or all of the individuals affected by the executive order have no rights under the due process clause. Now, you remember the problem of deporting people without due process is, how do you know that those are really illegal immigrants, right? What are you going to do? You don't like their looks? What's the proof that these people should be deported? The states argued originally that the executive order violates the procedural due process rights of various aliens in 3 different ways, and they go through those so you can see where we're headed. And again, a really important finding: the procedural protections provided by the Fifth Amendment due process clause are not limited to citizens. Rather, they apply to all persons within the United States, including aliens, whether their presence here is lawful, unlawful, temporary, or permanent, they all get due process. This applies to certain aliens attempting to re-enter the United States after traveling abroad. And there was an attempt to somewhat blur some of these points when the White House counsel said, well, Part 3C and 3E of the executive order do not apply to lawful permanent residents, but the court then says, at this point, we cannot rely on the government's contention that the executive order no longer applies to lawful permanent residents. The government has offered no authority establishing that the White House counsel is empowered to issue an amended order superseding the executive order. That has not been done. It could be done in the immediate future. The White House counsel's interpretation of the executive order is not binding on all executive branch officials, and he is not known to be in the chain of command. So, stepping stones on the way to finding that the TRO stands. We'll be back in a minute on World Crisis Radio. Welcome back to World Crisis Radio. Just one or two more key points out of the Ninth Circuit opinion. Reading still from that opinion, and here we are now on page 25. The judges, the three, note, per curiam, the states argue that the executive order violates the Establishment Clause and the Equal Protection Clause. Equal protection of the laws, everybody gets it. You can't establish a religion, First Amendment, because it was intended to disfavor Muslims. In support of the statement, the states have offered evidence of numerous statements from the election campaign about the intent to implement a Muslim ban, as well as evidence that suggests the executive order was an attempt to implement a Muslim ban. So what they're doing here is to say we are not limited to simply the textualism of the actual executive order, but we're entitled and we have to take into account the context, the political background of this, and so forth. So the government has pointed to no evidence as we go on now to page, the following page, which is now page 26. The government has not adduced evidence to show that a stay is necessary to avoid irreparable injury. In other words, what's the big hurry? You haven't proven it. And the 7 countries have been of concern in 2015 and 2016. The government has not offered any evidence or even an explanation of how the national security concerns that justified these designations under Obama, which triggered visa requirements, can be extrapolated to justify an urgent need of the executive order to be immediately reinstated. So the TRO stands. Anyway, let's say that's enough. Again, I urge you, that's one of the vital texts of our time. You should get it. It's extremely important, and go through some of those precedents, right? Go through the case law, because in this case it's extremely important. Now, where do we get this? First of all, let's say where we don't get it, right? Where we don't get it is from the English common law. We don't get it from the British Parliament, right? From the English or British constitutions. They don't have this. They do not have judicial review in the way that we do, and we are lucky, as you can see now. We are damned lucky to have judicial review. Here we go with the most obvious source, the Wikipedia article here, the judicial review in English law, and there's a bunch of stuff here, but main quote, unlike the United States and some other jurisdictions, English law does not, repeat, not permit judicial review of primary legislation, laws, i.e. laws passed by Parliament, except in a few cases where primary legislation and this is very, very recent and may not be in effect for long, except in a few cases where the primary legislation is contrary to European law, European Union law, or the European Convention on Human Rights. So whatever the British Parliament does becomes the Constitution. No, but this is the absolute reverse of the U.S. system. Right? The U.S. system, the Constitution is above the Congress, above the president. It's above the courts, too, even though they get to interpret it. But in the British system, anything the Parliament does, no matter how ill-considered, even things that the British executive does in secret, become part of the Constitution. What is this? Right? This is no judicial review worthy of name. And notice also another insight into why there's this, this dislike of that, nasty European superstate, right? The Brussels Eurogarchs and Eurocrats and all that stuff. We know those arguments. But one of the things that they don't like about the European Union is that this is for the first time a body of law that says this is superior to the British Parliament. So you can't just go wild when you get a parliament, essentially what it means is the British oligarchy in Parliament assembled decides to pass some liberticide law, right? Some law that undermines freedom. And, as long as the government ministers and the prime minister and the majority of parliament, if they want to do that, there is nothing to stop them. Nothing. What the British courts can do is to supervise details of the functioning, right? But not to say that the underlying law is unconstitutional. They just don't have it, right? Where's the British Constitution? Again, it's very vague, very nebulous, does not exist anywhere in formal written form or in informal written form. It just, you can't find it, right? It's like the Tao. It's everywhere and nowhere at the same time. So it does not come from that, but it comes from a tradition here in the 13 colonies. And, let's go right to the founding fathers. We're going to get to Hamilton. He's our main founding father on this as so much else. But in the debates at the Constitutional Convention, we have, for example, James Madison saying a law violating a constitution established by the people themselves would be considered by the judges, federal judges, as null and void. George Mason, not our favorite guy, but at least on this one he was correct, federal judges could declare an unconstitutional law void. And he says the judges could do this. Now, in the state ratification debates, again, take a look at the Judicial Review in the United States on Wikipedia, and you'll see that in the ratification debates in a number of states, this is considered to be a plus. But let's get right to the Federalist Papers. Now, you got to read along with this too, okay? Heavy-duty intellectual work here on World Crisis Radio. Keep up with the law. Now, what I have here is the Federalist Papers by Hamilton, Madison, and Jay. This is the Clinton-Rossiter edition. So Clinton-Rossiter, you know him. He was a legal and historical expert, professor of American institutions at Cornell University. I've actually seen him there many years ago in the early 70s. So Clinton-Rossiter edition. This is the mentor book, New American Library. You might have it as a signet paperback. I think it's dated 1961. So anyway, let's jump to Federalist 78. When we come back, we're going to hit you with Federalist 78, written by Hamilton, which is the definitive statement of a founding father in the original group on what's going on here. Back in a minute. Welcome back to World Crisis Radio. Now, you notice this argument at the Constitutional Convention is that the Constitution expresses the will of the people, right? It's we the people. But a law coming out of Congress or some state legislature from time to time expresses more like the will of those politicians who voted for that law, so that the Constitution, the superiority of the Constitution, is because it comes from the people. It was debated, it was ratified. That's why it's so hard to amend the Constitution, because you got to get 2/3 of the Congress and 3/4 of all the states. That's a tall order. So what they're trying to do is to say this is not going to be a momentary majority of 2% like Brexit. No. For big decisions, it takes more, and you can't just have even some kind of hoked up referendum. That will not do. So here we go again. Number 78 in the Federalists, right? This is in the Clinton-Rossiter edition. We're going to be looking at page 467 for those of you who are following, and I urge you to do it. Hamilton writes, "We proceed now to an examination of the judiciary department of the proposed government." Okay, and what does he say? "It is far more rational to suppose that the courts were designed to be an intermediate body between the people and the legislature in order, among other things, to keep the latter, the legislature, within the limits assigned to their authority." Now, this is just as good for the executive. "The interpretation of the laws is the proper and peculiar province of the courts." Later on, we're going to hear John Marshall say, it is the courts who say what the law is and apply that what it is to an individual law. Hamilton, again, "The interpretation of the laws is the proper and peculiar province of the courts. A constitution is in fact and must be regarded by the judges as a fundamental law. It therefore belongs to them, the judges, to ascertain its meaning as well as the meaning of any particular act proceeding from the legislative body." And again, we add from the executive. "If there should happen to be a variance between the two, they ought, of course, to prefer the Constitution. The Constitution ought to be preferred to the statute. The intention of the people should be preferred to the intention of their agents, the elected politician. Nor does this conclusion by any means suggest the superiority of the judicial to the legislative power. It only supposes the power of the people is superior to both, and that where the will of the legislature, or executive, declared in its statutes stands in opposition to the will of the people as declared in the Constitution, the government should be guided, the judges ought to be governed by the latter, by the Constitution, the will of the people. They ought to regulate their decisions by the fundamental laws rather than by those which are not fundamental." Now, he's talking about laws. We're here dealing with executive orders. So this goes on. Hamilton is one of the sources, I think, quoting Montesquieu, which is that the judiciary is the weakest of all the departments, right? It doesn't have the armies and the bully pulpit of the presidency. It doesn't have the control of money and appointments, which is in the Congress. The judges can never attack with success either of the other two. All we can hope for is that the judiciary will be able to defend itself against the attacks of the other branches. How about that? So as long as the judiciary remains truly distinct from both the legislature and the executive, then you have a situation in which the rule of law can be preferred. But the judges, as he points out, they are in continual jeopardy of being overpowered, awed, or influenced by the coordinate branches, by the executive and by the legislative. And it may be regarded as an indispensable ingredient in the Constitution as a citadel of public justice and public security. The complete independence of the Court of Justice is peculiarly essential in a limited constitution. And again, limitations of the power of the political branches can be preserved in practice no other way than through the medium of courts of justice, whose duty it must be to declare all acts contrary to the manifest tenor of the Constitution void. And here he argues they've got to have life tenure. In other words, the federal judge has got to be in power for life, because otherwise they will not be able to resist the political pressure of the other branches, be it legislative or executive. All right, so that's the Federalist. Federalist 78. There's also there were other proposals, right? Should the Congress decide whether laws are unconstitutional? No, because that, again, you have to have separation of powers. Jefferson thought that the president ought to decide what's constitutional and what is not. No, that would put too much power. That would be the imperial presidency. And the one about the Congress, that would again have a congressional domination, which would be bad. Even the anti-federalists realized that the U.S. Constitution creates a very robust judicial review, and the people who didn't like the federal Constitution said, we don't like it precisely because it lets these judges and not somebody else, state governments or something else, decide. There are these precedents. Let's just mention one of them. The most prominent is Hilton versus United States, Hylton. Is it lawful to put a tax on carriages? In other words, horse and buggy, I guess. This was reviewed by the Supreme Court, and they said, yeah, you can do it. So that doesn't really stack up as the great moment. But the great moment is Marbury versus Madison, 1803. This Marbury comes, he wants to rid of mandamus, and Marshall says the Constitution, as the voice of the people, establishes a government of limited powers, and the limits established by the Constitution would be meaningless if these could be overridden at any point by precisely the president and the Congress that they're designed to restrain. If the limits can be surpassed at any point by the people that are supposed to be restrained, then you don't have any limits. And here's the great quote. It is emphatically, writes Chief Justice John Marshall, 1803, Marbury versus Madison, it is the province and duty of the judicial department, judiciary branch, to say what the law is. Those who apply the rule to particular cases must of necessity expound and interpret that rule. And if two laws conflict, the courts will decide. And if a law is in contradiction to the Constitution, the courts are to regard the Constitution as superior to any act of the legislature, meaning Congress or some state. Now, why is this such a landmark? Here we have a guy called Professor Alexander Bickel. We'll give you his view on why this is such a watershed in just a minute. Welcome back to World Crisis Radio, and we're now in our final segment here in our program for Friday, the 10th of February, 2017. But these are the enduring questions, right? This is the stuff you've got to master if you want to be politically effective in today's world. So let's just say, well, what is the greatness of Chief Justice Marshall? And the point is, he puts it all together in a way that had not been done up to that time. So, according to Wikipedia, Marbury versus Madison, 1803, this case has been regarded as the seminal case with respect to the doctrine of judicial review. Some scholars have suggested that Marshall's opinion in Marbury essentially created judicial review. That's too much, because we can see, Hamilton talks about it. We have these other pre-Marbury cases. In his book, The Least Dangerous Branch. Now, this is called The Least Dangerous Branch, the Supreme Court at the Bar of Politics by Alexander Bickel, 1962. So far from the conflicts of today. Bickel writes, the institution of the judiciary needed to be summoned up out of the constitutional vapors. It needed to be shaped and maintained. And the great Chief Justice, John Marshall, not single-handedly, but first and foremost, was there to do it and did do it. If any social process can be said to have been done, right, accomplished, completed, at a given time and by a given act, it is Marshall's achievement. The time was 1803, and the act was Marshall's decision, opinion, in the case of Marbury versus Madison. So this then we go into lots and lots of history, all sorts of things. Again, I would urge people to read this stuff. So, as Hamilton already says, right, the federal judges need support. They've got to be encouraged, right? Public opinion, the press, right, which is an important element of the checks and balances, need to get mobilized. So what you see here is a combination of the federal judiciary, primarily, acting as a check and balance, together with the states. And this is what we have, right? This is it's the genius of this system that no matter how much power one party may seem to have in Washington, there are these federal judges, and a lot of them, appointed going back to Carter. I'm sure there were people who go back to Ford. Probably people go back to Nixon, even today. So the federal judiciary is something that we have to hold in high regard and provide some political support as merited. And then also the state governments, right? If you saw the Attorney General and the Solicitor General of the state of Washington, you can see that they have done yeoman service for the cause of liberty. And the other thing is the public. Now, we've had to devote our time to these long-term questions. The effect of the Women's March held on the 21st of January has been colossal, right? It was the biggest single demonstration in United States history. I wouldn't regard it as a woman's march. I think you got to get out of that mindset. This was a movement of the entire American people demanding constitutional rights, permanent rights, the inherent rights, including, I think, the Franklin D. Roosevelt rights, right? The second Bill of Rights of January 1944 that we never quite got because FDR died too soon, and he was prosecuting a war after all. So now the people who put together the Women's March, and our hat is off to them for doing this, they want to know what to do next. And the idea that they've come up with is to have a second installment, and this is called the General Strike, A Day Without a Woman. And the idea is that women should not gather, maybe they should, but the principal thing is that there should be a general strike by all women. And I think if you look at the pages where this proposal is brought forward, there's a lot of doubt that this is an effective tactic. There are people there who say, why don't we just have a day when we don't spend any money? Nothing could be more pointless than this. I can remember back in the Iraq War era, there was an attempt to make an impression by not buying gasoline on a certain day. Nobody ever noticed this. This was absolutely impossible. It had no concrete effect. So we're getting into the realm where I'm afraid petty bourgeois individuals coming into politics maybe for the first time have very confused ideas about what to do. Let me try to provide some ideas. And this also has to do with how do you deal with Congress, because we noticed that the Our Revolution group, as well as the Indivisible group, they're telling you to act on Congress. Here's what I learned about Congress when I got to Washington, pretty much permanently for the first time in the late 70s, or at least intermittently in the late 70s under Carter. I got a briefing from some people who had been here for a while saying, here's what you do when you go to Congress. When you're dealing with a congressman, the first thing you tell them is what you want them to do. And they will ask you, and I've had this happen to me many times. They'll say, okay, what do you want me to do? They come in, sit down. What do you want me to do? And at that point, don't waste your time with the motivation or the reasons. Tell him what you want him to do. You can't go in there and say, you should realize that women are indispensable. He'll say, I already know that. That gets us nowhere. What do you want to do? Well, we want to save Obamacare. That would be program minimum. Program better would be, we want Medicare for all. Program optimum would be, in this particular case, we want Medicare for all paid for by a Wall Street sales tax. We want the Wall Street predators who caused this conflagration to pay for the human victims. And as I was told by the people who were giving me this briefing, they appreciate this. In other words, a congressman wants to get to the point. They have limited time, and they want you to be blunt. That was what these guys told me. They said, be blunt. They appreciate it. If you're dealing with a staffer, right, the staffer is often some kid with a yellow pad, and you're sitting there, and the kid looks, he or she looks like they just got out of a fraternity or a sorority, and they sit there. If they don't write anything, you've got to say, look, what you want to tell the congressman or what you want to tell the senator is Medicare for all, paid for by a 1% Wall Street sales tax on all transactions, including derivatives. Please write that down, and please relate that to your boss, right? Because these are the little AAs, or I'm sorry, the LAs, right? The legislative assistants. If you get an LA in the congressional office or an AA, you've got to say, look, this is what I'm asking for. Then, if you're lucky, they'll say, why do you want that? Or how would that work? Then you go into the motivation. Then you say why you want it. But the first thing you've got to do is to say,